Good afternoon, everyone. I hope you guys are doing well. My name is Saif Ali. I'm one of the attorneys here at Monty and Ramirez. With me is partner Sarah Monty, and today we're going to be talking about the impact of the first 100 days of the Trump administration on business immigration. Initially, when we did this webinar about, um, I think it was a week after the Trump administration's um, when they first came into office, we had a few predictions and a few projections about what we thought might happen in the business immigration space going forward. And we're going to kind of revisit these issues and see what's come true. And a lot of our predictions were on the right track, and where we've seen things that weren't predicted or that were unpredictable, given the nature of this administration, we'll reflect on some of those items as well and discuss really what has changed and what the landscape is looking like now that the first 100 days of the Trump administration are over. Some of the topics we're going to be covering are the impact on the immigrant visa process, the perm labor certification process, and non-immigrant visas as well, which includes H-1Bs, TNs, Os, Es, Ls. We'll also discuss the changes in the enforcement and compliance priorities from ICE and from Department of Homeland Security. And we'll also discuss some travel difficulties and the extreme vetting that's going on in when it comes to travel and with the Department of State. And then Sarah will take over and she'll discuss the USCIS NTA policy and the alien registration requirement, as well as the impacts that international students are facing, and also the impact on other work authorized statuses and programs like DACA, TPS, and humanitarian parole. So if you attended our first seminar 1 week into the Trump administration taking office, we predicted that not a lot would change in the realm of immigrant visas and perm. And to a certain extent, I think that prediction has been accurate. The changes that we've seen so far in this realm have mostly stemmed from administrative blockages, slowdowns in processing, and increased scrutiny. But what we haven't seen are policy changes or regulation changes that have really impacted the way that perms and immigrant visa processing is taking place. It is important to note right now that, as we kind of predicted, that those reductions to the federal workforce have led to increases in processing time. The perm process overall right now, from start to finish with the Department of Labor, is taking anywhere from 22 to 24 months without audits. And really, when we're looking at audits, it can get close to 30 months, just shy of, 3 years, about 2.5 years. So really, employers should be planning ahead. And be sure to discuss future roles and promotions for employees. Perm is a forward-facing program, so it's become long and drawn out, and that doesn't necessarily reflect, fluidity and upward mobility and promotions that employees can earn. And so it's important to put a lot of forethought into this process now, given the processing times and really how long this takes. We're also seeing the return of interviews for employment-based green card applicants. Those were being waived for the most part during the Biden administration, but because of extreme vetting and the increased scrutiny across the board, we're going to expect more interviews for the applicants. We're seeing increased scrutiny and difficulty for EB-1 and EB-2 national interest waiver petitions. And one of the worrying things that we've also started to see is that the Trump administration has indicated its plan to start vetting applicants for anti-Americanism. That can include criticism of the government. Unfortunately, it can include criticism of the president himself. It can include a speech regarding foreign issues and controversies. And also, the Trump administration has signaled that it's going to start asking employment-based immigrant applicants for really actually all immigrant applicants, but also employment-based immigrant applicants for their social media profiles and handles, so that they can also, monitor the social media activity of immigration of immigrants. So, of course, while we believe in First Amendment and free speech rights, we do want to caution employees to watch what they post on social media as they go through the immigration process, because we do anticipate that there's going to be some scrutiny on that. Now, when it comes to non-immigrant visas under the Trump administration, one of the most interesting things we've seen so far is that the Biden H-1B modernization rule, which was published on January 17, 2025. So it was actually right as the Biden administration was going out the door and the Trump administration was coming in. This rule was published, and really interestingly, we haven't seen the Trump administration indicate any intention to roll that rule back. That rule has had some impacts on employers, some key impacts. And one of the key issues that it raised for employers is that it's changed the definition of specialty occupation. Essentially, what it means is that for employers, you can no longer have what's called a generic H-1B, which is, you have a position and it requires a bachelor's degree in any kind of field without any specificity. The rule is changing that so that now a position has to require a degree that correlates to that position. So, for example, an IT profession would have to require a bachelor's degree in, computer science, but maybe a bachelor's degree in chemistry would not really qualify that individual for that role. So, or any bachelor's degree would not necessarily work. So, employers are going to have to be specific when it comes to H-1B degrees. And also now one of the biggest changes is that an amendment is required before any material change happens to an H-1B position. So if you have an employee that's located in Houston, but you'd like to relocate them to Austin, or you're giving them a promotion, amendments need to be carried out before any changes to the job occurs. And that's a very key element of the rule, because now the rule also made a change to the provision that the Trump administration may take advantage of, and that changes that if an amendment is not filed, it can invalidate the entire H-1B, and the government can actually roll back that H-1B and revoke it if they see that there's been some kind of material change without any corresponding amendment. Additionally, we're seeing an increase in denials and requests for evidence. Interestingly, the Trump administration has signaled that they might be resorting to biometrics collections for people who apply for H-1B and other immigration benefits. That wasn't really happening before. Fingerprinting was mostly happening either if you went to the Department of State for visa stamping or for immigrant applications. And in certain cases, biometrics were being waived, but now we see that the Trump administration is going to be issuing requests for evidence to collect biometrics for applicants. Again, we're seeing challenges to certain specialty occupations. Entry-level positions might be under target. Degree requirements under the Biden modernization rule, those might be targeted. And of course, in the first Trump administration, we saw third-party placement with consultants and contractors was also being targeted. Right now, the H-1B lottery has just kind of gotten underway. So, we anticipate having a lot more information about how the H-1Bs will shake out as we hear back from our own experiences and from the experiences of other practitioners in the H-1B field, as to what kind of challenges we'll see this H-1B season. Again, we're seeing more issues at the consulate. This ties back into the extreme vetting. There's been a restriction in interview waivers. So essentially, applicants for for non-immigrant visas, when they go to their embassy in their home country, when they went through the process and scheduled their appointment, they may have received an an interview waiver. But now we're seeing that the consulates are canceling those waivers and requesting that those applicants come in for a physical interview to present their documents and speak to a consular officer. And that's increasing delays. That's causing the employees to spend more time outside the United States. And so, part of that, we are telling, employees to avoid non-urgent travel. There's been news where people have had their H-1Bs and other non-immigrant visas revoked when they're re-entering the country by CBP because they found something in their phone that related to what was considered anti-American behavior or threats to national security. So it is a difficult time for travel, and we'll talk a little bit more about that later, but non-essential travel should be avoided. We're also seeing an increase in enforcement and compliance actions. Essentially, the Trump administration has set a quota of how many undocumented immigrants they want to deport on a daily basis. And so far, they're falling short of that target, their internal targets. As a result, we anticipate that the area that they're really going to step up in is enforcement operations in workplaces. Tom Homan, who you may have heard of in the news, the so-called border czar, has indicated, recently, even in the last few days, that they've increased, workforce enforcement actions to a triple scale, and that they anticipate another tripling of enforcement actions because they are frustrated by lack of local law enforcement cooperation in carrying out community arrests, and so they anticipate making up their numbers in workplace arrests. That is going to come in the form of ICE, investigations, potentially raids, ICE compliance enforcement. That's going to come I-9, I-9 compliance enforcement, E-Verify expansion, perhaps making that a required element and no longer an optional thing. Additionally, unfortunately, key oversight offices in USCIS and Homeland Security have been closed. So the USCIS Ombudsman's Office, for example, the Civil Rights Detention Office, these offices were watchdog offices that were semi-independent of, DHS, and they were very helpful in assisting in cases where USCIS would fall behind or make errors that they refuse to correct. The next step would be to go and submit an ombudsman request, and we know in the past we had a great deal of success with the ombudsman in forcing USCIS's hand in adjudicating a case that fell behind, or issuing corrected notices. Or in the case of the Civil Rights and Detention Ombudsman, if ICE was violating civil rights or detention policies, the ombudsman could step in. But those offices no longer exist; they've been shuttered, and it's part of the Trump administration's compliance efforts to maybe kind of frustrate efforts to get helpful adjudications. Another thing is that the Biden modernization rule, and that's the interesting thing. This is a Biden rule. We think that the Trump administration may utilize it to increase enforcement when it comes to USCIS monitoring whether employees and employers are carrying out their H-1B responsibilities. The modernization rule had parts of it that increased USCIS's power to carry out investigations at work sites, including possibly even remote work sites. And where they would determine whether employers and employees were acting in compliance with the H-1B attestations and rules. Even though that's a Biden era rule, this modernization rule is still in place, and it is a rule that the Trump administration could leverage in order to increase its reach and power when it comes to enforcement and compliance actions. And then finally, or not finally, but one of the last things that I wanted to cover was that we're seeing what's called extreme vetting, and that's really playing out when it comes to the difficulties in travel. When we first did this webinar, one of the things we predicted was that a travel ban would be forthcoming very shortly. So in one of those cases, we're actually glad to be a little wrong. The travel ban has not been enforced yet. There's been a lot of news and a lot of news reporting about what may or may not be in that travel ban. But in early April, the State Department more or less asked to postpone their timeline. Initially, it was supposed to be within 60 days, but the State Department says that there's no timeline for when these travel restrictions are going to get announced. So although there's been a lot of news about what might be in those travel bans, for example, news outlets have talked about more countries and different levels of bans. So certain countries may face full bans, while some countries might face partial bans. Nothing concrete has been announced between now and early April when the State Department essentially postponed announcement of any travel bans. However, across the world, the U.S. immigration authorities are enacting the extreme vetting part of President Trump's executive orders. So what that means is that we're seeing security policies and screening and delays throughout the entire immigration system, but particularly abroad at the State Department as well. And what that comes out to mean is that people are waiting longer for their visas. There's delays and increased denials at the embassies and consulates. As we talked about a little bit earlier, those interview waivers that were being granted for H-1B and other immigration renewal stampings are no longer being granted. So applicants are now required to appear in person, even if they frequently applied for and been granted that visa in the past, even if they have no negative history in their immigration history. Those interview waivers are being scrapped in favor of in-person interviews now. There's been more what's called administrative processing, which means that cases are essentially given a provisional denial while the State Department carries out background checks and vetting processes. This can cause a lot of delays. So these delays can not only backlog the system, but if you have an employee that's going out into the United States, or excuse me, out of the United States in order to, apply for a visa stamp, uh, that can, essentially it's backlogging the system for them, and it's causing them to remain outside the United States for longer, which can impact your business. It can impact their ability to return to the United States, and their availability to work. So employees should be exercising significant caution when they travel internationally. Avoid all non-essential, international travel. Recommend over carrying documents to evidence status and maintenance of status. Employers should be willing to help, with issuing employer verification letters, making sure that the employee has their most recent pay stubs to show that they've been complying with the terms of their non-immigrant visa. Dependents for the principals, so the spouses and children should make sure that they have the documents to prove their relationship to the primary beneficiary. So, for example, marriage certificates, birth certificates for children, things like that should be the family should make sure that they carry those documents. And also, another key point is that we are advising all travelers, employees, and also immigrants in general, to make sure that when you leave, before you leave, that your I-94 was issued correctly, that you don't encounter any travel difficulties, or maybe you discover some kind of error on your I-94. That's something that can be corrected before you leave, because if you leave with an issue on your I-94, that can cause problems when you return. And also when you return, to make sure that your I-94 is issued correctly, so that employees don't encounter issues further down the road. All right, I'll turn it over to Sarah here to discuss the USCIS NTA policy and some of the additional topics that we're going to be covering this evening.
It's safe. You're going to continue to drive, right? But
Yes.
and I just wanted to comment on a couple of things that you were talking about. Regarding the travel, I think that one of the things that I'm doing too is the signatories for the employment verification. I'm actually kind of uh, just, if there is someone coming in, maybe coming in for the first time, just alerting the signatory of that letter, because they might get a letter from CBP. I know that we've had a couple
Yes.
where there has been, right? You've seen that as well,
Yeah.
right?
Yeah.
And you know what's funny? I know that everything, that the whole thing about having to share handles, but about social media and so forth, and that is disturbing. But really, for Department of State cases, we've actually been doing that for a while.
We have.
There
Yeah.
had been that request. I never thought that people would actually go and look, right? I guess that's the
Right.
difference now,
Right.
that somebody is actually doing that. And what I've been telling folks too is that if we look at it, we've got to take lots of patience before we travel, but also understand that these officers, they're being put under the gun. They're being mandated to do these things. I'm sure this is all part of their performance review, so this is kind of the environment we're in, right? It's kind of troubling, but that's basically what we have. And as you say, avoid all non-essential travel. And we hate to hear that, right? Coming out of COVID, we were all wanting to travel, and we just don't have that. You've got to think about it. What's the cost of it? Okay, but thank you so much. So let's talk about the NTA policy, and an NTA is basically the charging document. If you get one of these documents, it's basically your invitation to go and defend yourself before a deportation, the immigration courts. Okay, so it's something you don't want to get. So they've promoted this NTA policy, and basically what they're saying is that if you file certain business type cases, maybe it's an I-129, it's an H-1B, a TN, an O-1, and if that case is denied, in the old days, well, you know what, you've got a denial, bad luck. Hopefully of course you have to be in status if you want to remain here, but there was never any consequence. Now, under this USCIS NTA memorandum, they're saying that, you know what, you could be put into proceedings. So that is very troubling, because we've never seen that attitude with employment-based cases before. So this means before moving forward on any case, you've really got to think about it, okay? And so far, I think that we've heard that it's going to mostly impact non-immigrant visa cases, right? But I think that we've got to be ready for that. And before, let's say that you, for whatever reason, maybe you've run out of H-1B time, might be thinking about going to an O-1. Maybe you should sit down with counsel and really see that you're putting together a good case. If not, you might find yourself having to defend yourself in court. So how that will work, we don't know, but we do know that a policy has been issued, okay? And so they're no longer exempted cases. It's not just going to be family-based cases. These are business cases. And they're just basically laying down the line. This is what it's going to happen. Know that this is an action. And referring to what Saif was talking to before, if the government's not meeting its deportation quota, well, they're going to go and do worksite raids. And then, they don't get enough there. Well, maybe they'll start looking for NTAs with people who are filing cases that get denied. So this is definitely a time to really scrutinize what you're doing with the government. Okay, let's go on to the next one. Okay, this alien registration requirement. This is so scary. Is that what they're calling it? The ARR? The R?
The R, it sounds like a pirate, yeah.
It does that. Well, it's an ugly thing. And the good thing is that this probably really impacts those individuals who entered the country undocumented, okay? If you are an employment-based non-immigrant, you've entered to the U.S. either maybe as a B1 or a B2, change status into a non-immigrant visa. So you actually entered in with an I-94. Those individuals are exempted under this rule. And this rule, what it says is that basically certain people have to register and submit to biometrics. It doesn't provide any sort of status. It's basically creating a file so that they know who you are. Okay, but in business cases, for the most part, there's a very small group of folks, right, who will have to register that hadn't registered, and it's those children who under 14 that came to the U.S. and turned 14. So before at the consular post they weren't 10 printed. So now that they are 14 years old, they're going to have to be 10 printed. And so that's probably the group that is going to be impacted. What we've got our friends, the Canadians, a lot of times they enter the US and they won't be given I-94s. Those folks who don't have that will have to, if they enter in and they're not issued an I-94, and that's routinely done with Canadians. Those Canadians will have to actually go ahead and register. Okay, so again, the rule is definitely for those folks who fit this parameters and that are here for 30 days or longer. Okay, but for most business folks, you're exempted because they've already got your biometrics. They already have your details. Okay, so that's good news, except for that small group of people, young people that were turned 14 in the US. Okay. And just to say something about that, you were mentioning that that for like the H4 process, H4s had routinely been subject to biometrics, and if you had a change of status, let's say from B2 to H1B, there wasn't necessarily biometrics. So we're going to be seeing that as well, right?
Right. Right.
Okay. So we're seeing that closing the circle, trying to make sure that that they've got everybody. And I should note too that they're probably hoping to use a lot of AI in kind of going through all the government records, right?
Right.
Okay, so they probably have the technology to do it. Whether they have the manpower to do it, we don't know. But we do know that all other federal government budgets are being cut drastically. But DHS is the only one, I think, that is going to be receiving a lot more funds to do what they have to do. This
And
is, I think, the administration's banner program. They feel that this is why they were called into office and their mandate. So they're taking this very seriously.
yes,
Okay,
and
next
DHS
slide.
is actually hiring right now, so
Oh,
they're clearly
they
their
are
budget
hiring.
is not, yeah, their budget is not being cut at all.
Oh, well, okay. Be warned. Let's go on to the next one. Okay, this is one group. This is one group here that, oh Lord, they have been hit and they've been hit hard. And this reminds me, remember under first Trump administration, right after the inauguration, DACA was actually terminated. Okay.
Right.
So basically, and we'll talk about DACA in a bit, DACA right now has been left alone generally. But my goodness, how they've come against the F1 students and the OPT. Okay. And so under the wide, what is anti-American? Well, what's anti-American to me is not the same as anti-American to you. But under their definition of what is anti-American, we've seen lots of F1 students visas. Um, well, actually, it's not really their visas. They've been revoking visas, but more importantly, they're revoking their status within the US. Okay. So heavy scrutiny against F1 students for anti-American activity and criticism of government or foreign policy issues. Okay. So this is not the time to be very vocal about your political beliefs. Okay. For the longest time, we believed under the case law and a constitution that we had freedom of speech. Well, you're going to see these cases going to the Supreme Court, whether legal permanent residents really have a freedom of speech, whether temporary visitors do. And we're going to see these series of cases being litigated now. Okay, so what we believed to include freedom of speech for everyone, I think we're going to be seeing that maybe it's not for everyone. Not looking forward to seeing those cases, but I think we're going to see them being played out in the courts. ICE apprehensions, and it's important to note F1 students, that SEVIS program is actually directly monitored by ICE. Okay, so that we have seen some disturbing ICE apprehensions, and going back to when do you have the most likelihood of having trouble? If you're coming in, when you're coming into the US, you go through inspection. Everyone goes through inspection. So that's why when SAFE says, cut out all unnecessary travel, he really means it, because in the same way that if you're in the US, when are you most likely to encounter law enforcement? And that's when you're driving. Okay. So this coming into the US, you are exposing yourself to risks. Under the Patriot Act, and this is actually something that's been, since 2001, the government has given wide berth to CBP. They basically have, they're allowed to ask whatever they need to ask in the name of national security. So all of these, this activity is being done in the name of national security. So we've got to understand that. If you do have to travel, leave enough time to travel. Uh, understand that there could be delays and denials at the consular post that you may not have seen before. Again, every officer having to do with immigration has been mandated to vet and vet more. Okay, so it's part of what you're going to be experiencing. There have been there's been a little bit of reversals of SEVI's terminations by ICE. That's been good. So typically F1 students normally don't have attorneys because really the F1 process, most universities are very helpful in helping with the visa issuance or the change of status. But this is a time now when F1 students really have to start looking for counsel. This is a time where we've got to be in a defensive mode. And my recommendation to every F1 student that is here in the United States should find their own attorney and be ready to have to defend yourself. Okay, this is what we're seeing right now. There's no travel ban yet. And, under the first Trump administration, I think they were really hit hard by the courts. So I think I wouldn't be surprised if there's not even one in the future. If you can vet everybody, why have a travel ban, right?
Right.
So I think that we'll see. We'll see if if there is one, but it might just make more sense. They won't have to be taken to court. It might just make more sense to vet everybody, and maybe you keep people from coming in just in general, right?
Yeah.
And you know that there's going to be a lot of profiling, but
Hmm.
the government says the totality of the circumstance. But I guess that's the way it goes. Okay, let's go on to the next one. Okay, so far, again, DACA was hit hard under the first Trump administration, and there was so much litigation. And right now, where do we stand? Well, first of all, there is that lovely Fifth Circuit ruling, which upheld the finding that DACA is unlawful. Of course, DACA was created through an executive order, and that's kind of funny that now with all the flurry of executive orders going down, that's the way it's coming out. But yes, there is an upheld. The Fifth Circuit said that DACA is unlawful, but it's limited in scope only to Texas. Remember, Texas is the one that brought the suit. Texas is the one that was able to show the damages. Now, this injunction protects DACA recipients inside and outside Texas. The renewals are currently being allowed. And gosh, guys, if you have DACA, get it done 5 months in advance. Right now, they are moving those cases like fire, and I don't know why. And I guess I'm suspicious anytime the government starts acting really efficiently. But how long have they taken? It's taken 2 months. I had another one that took a month. So, but don't leave it till the very end. Remember, if you don't have at the expiration of your C-33, if you don't have your card, they will have to terminate you. So don't leave it to the end. But goodness, these are the ones that are coming out. The Fifth Circuit did remand the issue of Texas DACA, and they've separated the issue of protecting. There's two things that are granted by DACA. It's the protection from deportation, and then you have the work authorization. Okay, so that's been sent back to the lower district court, but for now, DACA remains in place in Texas. We don't know for how long. Those folks that have DACA, look for another way to remain in the U.S., whether it be through a family-based case, whether it be through employment-based cases. I know, Safe, you've actually been able to help some DACA folks on
Yeah.
H-1Bs that were lucky enough to get an H-1B cap case, and so uh, look, ask, but DACA's temporary, and it's going to be something eventually will be happening to that. So don't stay and not do anything else.
Mhm. And I think it's important for DACA holders to consult because it's not always obvious, but there are pathways, and you may and DACA recipients might have pathways and ways available to them that they wouldn't realize because the immigration law is so complex. But consulting with an attorney can bring out options that people didn't think they had, and some of those options can give a much greater sense of security, especially right now with Sarah touched on it with how uncertain waters DACA is in right now. If that option is available, it's now is the time to explore.
Exactly, exactly, and especially those folks with U.S. degrees. Ask about the 212 D3 waivers.
Mhm.
This is, what is it that, what is it? Invention is the mother of necessity. Am I saying that
Yeah,
right?
I think so. That
So,
makes
but
sense.
this is what we're having to do here. Okay, great. Let's go on to the next slide. Okay, so here, in the heavy-handed, again, anything that's Biden created, especially, Biden he did play a little fast and loose on his invention of all these different parole programs. And I guess what his purpose was his administration was trying to find legal pathways, even if they created the legal pathways. Well, uh, this Trump administration has come in and they basically shut down all the parole processes, right? Well, the ones that it'd be the CHNV parole, Cuba,
Mhm.
Haiti, Nicaragua, Venezuela. Okay, they have been terminated, although right now there is a court challenge, right? But
Yeah.
officially, if that's all you had was a parole document, how are we handling that from an I-9 point of view?
And so from the I-9 point of view right now, and parole is a little interesting because uh, the parolees, they get, unlike TPS or other statuses, they don't all have the same expiration date for their work authorization cards. And so essentially the way it's playing out right now, as a result of the court battle is, of course, it was terminated, but then the federal district court has placed an injunction. So specifically on the Cubans, Haitians, Nicaraguans, and Venezuelans. And so there right now, the way it's playing out from an I-9 perspective is that their work authorization is essentially expiring when it expires. So that April 24th deadline that the government put in for the entire parole program ending, that's no longer in play. We're advising employers to go based off of the expiration of the work authorization, whenever that may be. And it's going to be differing dates for each individual employee. So it's important to pay attention to that and re-verify based on the expiration of those documents.
Which is fair because an employer should not be asked to know the intricacies. And that's the basis of the I-9 program. An employer doesn't know what's happening. They know if they've got a card, it's valid, they're going to honor it, right? So
Exactly.
that's good news. That's good news that they can rely on that. Um, but we do have Venezuela TPS, so you could have somebody that has a Venezuela parole and a Venezuela TPS. That's currently in court battle, but the Venezuela TPS it's still valid, right?
Right. And actually,
Right.
interestingly enough, there was an extension in January 2025 by President Biden, where they brought back, rather they issued an extension of work authorization. So people whose cards were expiring in April 2025 now have their cards granted essentially a 1-year extension. And so from an I-9 perspective and from an employer's perspective, your employees that present some of these Venezuelan EADs, TPS EADs under the category C19 or A12. Those have received extensions till April 2026. So, it's been kind of a breather for the program and for the employees and everyone involved because it's given a little bit of life back into the program. But the unfortunate thing is, again, what's keeping it alive is an injunction by the federal district court. So as we see this case this termination of the TPS and the lawsuit go up and up the chain of federal courts up to the circuit courts and maybe even the Supreme Court, we may see changes, and employers should kind of make sure that they're staying aware and abreast of these changes, as they come along to the program. I think Sarah, during the last Trump administration, I think TPS was caught up in the courts essentially for
Oh,
the
yeah,
entirety of the Trump administration. So,
right,
you know, I hate to say it, it might actually be a best case scenario that the courts see this thing all the way through for the next 4 years.
right. And again, as with DACA, if you've got, imp you can move a case from a humanitarian-based case, like TPS, like asylum. Parole's a little bit different, I think, but, possibly, and try to move it to an employment-based category. And that is the type of things that folks should be looking at. One of the things to move a case from humanitarian to employment based is that you've got to be able to show maintenance of status. Um, and many times that can be achieved if there is a good faith asylum case brought forward, or if depending on an entry on a B2 entry followed by TPS. If you can show a maintenance of status, plus you are able to show that there has not been unlawful employment for more than 180 days. So again, you've got to talk to somebody that is well versed in the intricacies of moving across a case from a humanitarian-based case to an employment-based case, and it can be done, and we do it a lot. So those of you who might have a case like that, make an appointment, talk to us, see if there's a way of moving, because we can only depend on the courts holding back the tide for so long. Okay, at one point, things are going to change.
Right.
Okay, so great. And then so we've got I think our last slides, our last company is that, okay, so how do we prepare? Okay, what should we do? Okay, as far as a sponsoring employer. Um, you know, one of the disadvantages we have with all this other, you know, mayhem and everything else that's happening is that we have a backlog of immigrant visas. And, had this happened 4 years ago, I think 4 years ago, for most countries, there probably was an EB2 available, possibly even an EB3 available. And so, there was that out of being able to maybe file an adjustment, well, an I-1 after an I-140, through PERM, going through the 3 steps, filing your I-140, and being able to file adjustment of status, and being able to maintain status. We don't have that. So I think that's one of the biggest ways we are more negatively impacted now. And again, that is not because of this administration, although, we want to blame them for everything. We do have a backlog. We really do have a backlog. And that's very important for employers to understand. If employment-based sponsorship is expensive, it's now more expensive, and there's going to be more cost and more delays. So no good news there, okay? You're going to be spending a lot more money, unfortunately. When I think this is common sense, not you treat everyone fairly, but not everybody is treated the best. Or, look at your A employees. Those are the ones that you're going to have to, put your resources in. Closely monitor expirations. Meet with your attorney, with your counsel regularly to understand what is moving, what is shifting. One of the reasons when you were talking about the Biden H-1B modernization rule, with a few exceptions, I think one of the reasons that most, good practitioners who operate in this space are not so negatively impacted or haven't been negatively impacted by the implementation of that rule is that we learned those lessons. We were over preparing files. We had been looking at wage issues. We had been looking at specialty options. And maybe that was a gift from the first Trump administration. Maybe they trained us well, and we learned those lessons. So probably with the exception of the amendment, that the any material change has to be filed. That amendment has to be filed before the change takes place, right? The new
Right.
position. That's probably the biggest difference, right?
Right. Well, especially when it comes to promoting and being careful, because now it's more dangerous to go back and try to fix it after it's been done rather than taking care of it beforehand. I think
Because
that's
remember,
yeah.
we've got now the USCIS NTA rule, right?
Yeah.
So you could see a situation where you could have a denial because that amendment's denied because you promoted the person before you filed that amendment. So and if the circumstances weren't correct, you can't even take the amendment, right, until you get an approval. Right?
Right.
There's a little bit of a, you can port, you can use that porting to be able to take care of it. But with that could result in an NTA. And you know what the problem there is that if you're issued an NTA, if it's filed in court, it's not like if you can just leave and I'll go process the visa abroad, you know,
Hmm.
because an NTA, if you want to continue to live here, you're going to have to go to court. If you self-deport, that basically you'll have to be remain outside the United States for 5 years. So that is really negative. Okay, and that probably is the one area that is scary. Um, we have the old USCIS VI program. They've started quoting that in their RFEs, and that is a program that is it's actually managed by who is it?
Dun and Bradstreet.
Dun and Bradstreet. And we used to have all of our employment-based uh, employers kind of sign up and be able to prove the affiliations. Um, we're starting to ask for that again. Okay. And, this is a time where we have congressional liaisons. And, a lot of people think that when you go and run to a congressional liaison, that you're doing something illegal. I think people have to understand that that's one of the things that your senators and your House of Representatives at the federal level, that's one of the things they should be doing, is helping people with government agencies. So if you are an employer that has a nice size of foreign nationals, you need to find out who is your congressional person that you can reach out to when things are not going right, when you have an unfair determination. And thankfully, in the employment-based space, we don't see the blatant disregard for the rules and laws yet, as we might see in the removal context.
Mhm.
There we are seeing some real doozies. We're
Yeah.
really seeing some lawlessness, I think, on behalf of the government, but we're not seeing that yet with employment-based. But as we start going through this process, since we don't have an abundance unit anymore, which, by the way, right when they canceled it, it was just when they started getting the hang of it, right? They were
Yeah.
starting to really help us.
Yeah.
I think the first few years they were pretty useless, but they had started to help us, and then they killed the program. So that was
Yeah. Just as it was getting good.
just as they were getting good. So here, the only other alternative is to have again, sympathetic congressional liaison person. And you just go look at their voting record. Who do you have personal relationships? Do not jump around. They're very jealous. If you go to one, you got to stay with one. You can't be shopping the forum. Okay, and when you work with those, you've got to get your privacy request. You've got to go, and each one of them has a web page that tells you exactly what you have to do to go ahead and request the assistance. Again, they don't want to hear from the attorneys. They want to hear from the constituents. So that's one of the other things that we can recommend. And let's see. How can all employers prepare? Okay, it's the I-9. Mr. Trump is not going to be able to make his numbers, and he's going to be hitting work sites. And the work sites that are at the most risk are construction, manufacturing, farming, what else?
Restaurant industry.
Restaurant industry, okay,
Mhm.
hospitality. Okay, so if those of you who are listening to this who are decision makers, evaluate your I-9 process, conduct internal audits, prepare a response plan in case of ICE investigations. Plan on how to replace workers who lose status or are caught up in immigration rates. This is all happening when we have a terrible employment shortage. People don't realize that. We don't have enough employees. So this is a challenging time for people in HR. Monitor the statuses of your doc. Well, employers should be treating everyone the same, but know which programs are at risk. The C-33s, what is it? The A-12s, the A-19s.
C-19s, yeah.
Okay, look at those. Just be careful and try to right now. An employer can rely on the employment verification on the EAD for right now.
For right
That's
now.
safe? Yeah.
Yes.
Okay. Be mindful of the anti-discrimination provisions when hiring. Although did they shutter that the employment civil device?
Yeah, I think the DOJ's IER has gotten some cuts, and I don't know if they're going to be examining those same kind of cases. In fact, actually, there's some word that they might be looking at reverse, or what they so-called reverse discrimination or
Mhm.
affirmative action. So it typically the IER, which is the Immigrant Employee Rights section of the DOJ, and the DOJ in general was investigating, anti-discrimination against minorities and protected groups and non-immigrants and foreign employees. But now you're kind of seeing these agencies get weaponized in a reverse manner to now
So
are they
how would we see
discriminating,
that work out?
well, discriminating against maybe are you over relying on foreign workers at the expense
Ah,
of US workers and things of that nature.
I see. Yeah, it seems like that you employer are maybe discriminating against the white employee, basically the men,
Exactly.
maybe older employees. Okay, so all of this is happening, and so how can all employers prepare, stay informed, know what's happening? Again, thankfully, we haven't seen everything just go crazy and like we do in the humanitarian space. In the humanitarian space, they've stopped adjudicating adjustments for asylees. Uh, we have federal immigration judges' orders are not being respected. We have the Supreme Court kind of being pushed off to the side, their decision. So thankfully, we don't have that in this space yet, but you've got to keep and stay informed. Okay. And I think that's it. I think that's it.
That is, and I think we can maybe open up for questions from participants. If you have any questions, please place them in the chat, and we'll be happy to kind of answer them.
Yeah, because we've got a couple of minutes left.
We've got a few minutes left.
Okay. And as we're waiting for that, it's important to know that here at Monty Ramirez, we said from the beginning of the year we would come to you once a quarter. We're going to be telling you what to expect. Um, we're going to give it to you straight. We're going to tell you what's really happening in this space because it's different in every space. You've got to understand that. So I guess from this point of view, we probably will be looking for our next webinar. When is that going to be like? Is it going to be, when does the next quarter start? July 1st? About
July, yeah.
July-ish? Yeah.
Yeah.
So, but meanwhile, if you're not receiving our newsletters that come out monthly, in fact, Attorney Safe really works hard to get those out and get those to you. make sure and subscribe to them. We try to keep you and give you a little bit of a breakdown on all of those things that impact employment-based immigration. We have another one for family-based immigration and humanitarian immigration. So, sign up for that.